The expectation. The question of legitimate expectation would not arise when a position is altered by the rule or legislature, or where there is a public interest, or where there is a change in policy. Anand Kumar, Sharam, State of Uttar Pradesh. Taxing statutes. The duty of state is to act reasonably, having regard to equality clause, Article 14. Corporation Bank versus Saraswati Abha. Abhara Shala. Tender priority. Acceptance of tender by the tender committee would be proper, where the tender was finalized by the tender committee. Complaints of the terms and conditions laid down in the tender documents of the concerned tender notice. There was no allegation of violation of such statutory rules. Techno compact filters such as Northeast Frontier Railways, tender and arbitrators, where the tender failed to fulfill the norms of eligibility criteria, the decision to treat such tender respective would be contrary to the tender condition violation Article 14 of the Constitution. Supreme Mahavir versus Municipal Corporation of Greater Mumbai. Tender cancellation agreement. When a petitioner accepted the cancellation of his agreement on the basis of delay, he cannot be justified in claiming refund of reduction, which is also made in the same clause. Binne Prakash, the state of Bihar. So the petitioner accepted the cancellation of the agreement on the basis of delay. He cannot justify by claiming refund on the deduction, which is made on the same clause. Tender, forfeiture, and honest money. The claim based on the entirely different set of fact would amount to modify the offer. In such circumstances, forfeiture of the earnest money would be improper. So something has happened. Okay, Munish Kumar, Manzar, State of Punjab. The cancellation of tender process would be proper where any decisions has been taken after due of consideration. It is well informed decisions. Vedata Engineering Private Limited, State of Himachal Pradesh. Tender procedure of where a price of the highest bidder was found inadequate, and the state wants the same to be settled in the price with a price in a view. Article 14 of Constitution, all the bidder would have been invited for negotiation for enhancement of bid price and not only the highest bid. Umesh Kumar Bodar, State of Odisha. Tender process rejection. When submission of a tender on the before the last date of the mandatory, it is not essential condition that non-compliance would be fatal. Akhtar Hussain Ali Kasan Khan is a Surat Municipal Corporation. The competent authority has to decide accept or not to accept the bid. If a revised valuation of assets put into auction was much more than the bid offer, rejection of the bid would be proper. Suraj Singh, Sanjay Punjab. Rejection of technical bid would not be proper where a tender and condition of the tender did not prohibit the participation of an entity registered under the Societies Register Act 1980 and the memorandum of the petition permitted practitioner and carrying on the activities of nature. This petition failed bid. Patti Matha Drug Operational Society FCIAR. Tender terms and conditions. The fixation of the amount of EMD and secured deposit is within the dominant of authority, and the petitioner cannot question. The amounts of fees cannot be said in arbitrary or illegal. The Tapan Jina State of Orissa. See the Bimal Das was Assam Visionary Development Corporations. JKK Kerry Sons and State of Nagaland and Kumar Construction State of Bihar. Constitution of India. Arakambia petitioner was aware of the terms and conditions of the tender. After participation in the tender process, it would not be permissible for him to raise objection against the condition. Fleck Limited was a state of Sikhism. Tata Cellular was a state union of India. Test of equality. Determining the validity of the standard provision Court of India has followed the general principle of equal protection of law means right to equal treatment of their similar circumstances. Courts have upheld legislation contains appropriate discrimination provision where the discrimination is based on a reasonable basis. For reasonable, it is mean that the classification must not be arbitrary but also be rational. The classical test of justical enunciated requires for the following two conditions, namely, classification must be found an intelligent difference, which differentiate those that are grouped together from others. A difference must be a rational relation to the subjects are sought to be achieved by the law under the challenge. Judicial decisions lie down the important proposition on the subject of following. Chiranjit Lal, Union of India, State of West Bengal, Mrs. Anwar Ali, Dhirendra Kumar Mandal, the Superintendent and Legal Remembrance of Legal Affairs. Amiran Nisha Began, which is Makboom Begum Usaf, State of Bombay, R. Chitraleka, which is State of Mysore, Special Courts Bills 1978, General Manager of Southern Railways, which is Rangachari, Balaji, which is State of Mysore, T.S. Nakra, which is State of Union of India, Matoja, which is Bihari, Atam Prakash, which is State of Haryana, Pradeep Jain, Union of India, Hushi Usman Bai, Hassan Bai, Shura Qureshi, which is State of Gujarat, K. Timmappa, which is Chairman, General Board of Directors, State of India. Different procedure of large public interest permissible. In the matter of the coal block association, cases of different procedures has been adopted in a larger public interest as well as the interest occurred on non-discriminatory. Girish Kumar Shunija versus CBI uncancelled discretion. Uncancelled discretion vested in the administration authority and non-permissible Delhi Transport Corporation and Madur Union violation where an appointment of Rebel Young with a little education as SPO engaged in the counter in surgery activities made in Article 1450 of Constitution were violated and would continue to be violated. Nandini Sundar state of Chhattisgarh where an order passed by a statutory authority was arbitrary and clear violation of statute. The alternate remedy of appeal should not be bar in existence of jurisdiction of the High Court. State of Madhya Pradesh with the Sanjay Nagaya the requirement of being employed through proper channels cannot be relaxed in arbitrary and cavalier manner to benefit of the few peoples. That would clearly violate the Article 14 Article of the Constitution. Pondicherry, Khadi Village Indian Industry Board versus K. Rahi, Union of India versus Dharman Pal. A zone-wise merit list for recruitment. Preparation of zone-wise merit list for candidates for recruitment in all India service is unconstitutional, even if tests are held in different zone. Radhe Shyam Singh was Union of India. The prohibition of discrimination on the ground of religion of race, ground of caste, ground of sex, ground of place of birth. The state shall not discriminate against any citizens on the ground only on the religion, race, caste, sex, place of birth, or any of them. No citizen shall on the ground of the religion, ground of race, ground of caste, grade of sex, ground of place of birth, or any of them subject to disability be subject to any disability, subject to any liability, subject to any restriction, or subject to any conditions with regard to access to shop, access to public restaurant, access to hotels, access to place of public entertainment. And its use of wells, use of tank, use of bathing guards, use of roads, use of place of public resort, you and maintain wholly and partly on the state funds or dictated to the use of public general public. Nothing in the article should prevent the state from making any special provision for women and children. Nothing in the article in the clause 2 of Article 29 should prevent the state from making any special provision for the advancement for social and education backward class of citizens or for scheduled caste or scheduled tribe. Nothing in the articles, nothing in the articles class 2 of 29, class 2 of article 29 shall prevent the state of making any special provision for advancement of the any socially, educationally backward caste of citizens or for the scheduled caste and scheduled tribe. Nothing in the articles of class G of article 1, subclass 1 of article 9 shall prevent a state from making any special provision for law for the advancement of socially and economically backward, educationally backward, not economically, socially, educationally backward class of citizens or for scheduled caste or scheduled tribe so far as a special provision relating to the admission of educational institution, including private education institution, where aid of unaided by the state other than minority education institution referred to the clause 1 of class article 13. Nothing in the articles of class G of article 1 and article 19 of class 2 of article 29 shall prevent a state from making any special provision for advancement of any economical weak any nothing economically weaker section of citizens other than the class mentioned in clause 4 and 5. Any special provision for advancement of the economical weaker section of citizens other than the class of mentioned class 4 and 5 4 and 5 so far as in special provision relating to the admission to education institution including private education institution where aided or unaided of schools other than the minority education institution refer to clause 1 of article 30 which is the case of reservation would be addition to the existing reservation subject to them maximum 10% total seats of the category. Actually, for the provision or purpose of the articles and Article 16 economically weaker section shall be such as may notify by a state of time to time on the basis of family income and other indicates of economic advantages. Notes of on articles. To promote the education advancement of socially and economically backward class of citizens, that is OBC, other backward class and scheduled caste and scheduled tribes, in the manner of admission of students belonging to the categories in unaided education institution other than minority education institution, refer to Article 30 of Clause 1 of Constitution in the Article 15 of Clause 15 inserted after the Clause 14. The new Clause 15 shall allow enable the Parliament as well as state legislation to make appropriate laws for purpose of mentioned above. Area-wise reservation. Area-wise reservation Article 3(1)(d) prevails over reservation under the Article 15(4). Devarakonda Rajesh Babu, Nizam Institute of Medical Science. Backward class Article 14 of Article 15, a way of first sight appear to be a blanket provision. The protection any kind of beneficial discrimination in the nature of special provision for the benefit of clause mentioned therein. However, apart from the question has been particular class can be legitimately regarded to backward class and discrimination provided such a nature may be struck down unreasonable to the circumstances. It is a basis of general right of equality guaranteed by Article 14 would override the special provision of Article 15(4) in some circumstances. Hence, a reservation for expressly high percentage of seats in technical institution for each class would be void. Ordinarily speaking, reservations excess of 50% available seat may not be upheld. The undermined decisions may be seen at point. State of Uttar Pradesh versus USV Balaram Rajendram versus Union of India, M.R. Balaji State of Mysore, K.S. Jayashir versus State of Kerala, A. Periya Karuppan versus State of Tamil Nadu, Abdul Lafti versus State of Bihar, Anil Dean Government of Medical College Nagpur. It is making reservation for exclusive order for virtue of Article 14 and 15. The state has taken case that is a not undue wide. Apart from the scheduled caste and scheduled tribe in the other classes of eligible for reservation, it made the state register its category of socially and economically backward class of citizen. Undermined decisions may be seen on the aspect. K.C. Vasant Kumar, State of Karnataka, Comptroller and Audit General of India versus Jagannathan, Deepak versus State of Bihar. Aarti Shapuru, which is state of Jammu and Kashmir, and Nisha Mahu, which is state of Jammu and Kashmir, state of Madhya Pradesh, which is state of Kumari Nivedita Jain, state of Kerala, which is N.M. Thomas. The Constitution 93 of Amendment 2002, the Act 2005 and introduces Article 15.2 does not interfere with the executive power of state and not invalid for any of the following procedure. Article 368 Ashok Kumar Thakur versus Union of India. The placement of Article 15C of Constitution is the Equality Code by the 93rd Constitution Amendment 2005 is a great significance. What is does it enlarges as opposed to be truncating an essential and induced primordial future of equality code. Indian Medical Association is the Union of India. Discrimination. The cruel word in the art discrimination means making an adverse distinction whether regarding to or distinguishing unfavorable from others. Kadi Rain Rawat is a state of Saurashtra. Another crucial word is only, so that discrimination is based on the some grounds not connected with the religions, etc. But with such a rational factor, discrimination would be valid. The discrimination forbid the Article 15 of only such discrimination is par inter alia on the ground of person belonging to particular religions. Then such confound the clause of 1 of Article 15 being only on citizen. The same is the individual right to way of guarantee which may not be subject to discrimination right prevailing and immunities pertaining to him as a citizen. In other way, the right conferred in the Article 15 is a person. A statute which is rejected on a right to class of citizen in the manner of testimony or disposition which may belong to particular religion would therefore not attracting the wrath of clause 15 of the Article 15 of Constitution of India. John Valla Matton is a Union of India. Institutional preference based on the domicile would be permissible unless a discriminatory Nikhil Hindani state of Uttar Pradesh. Racial discrimination against a person of northeastern states would be stopped when the apex court directing union government to constitute committee and ventilate such grievance and the proper redressal of karma dorji is Union of India. Discrimination on ground of sex. The exclusion of women is not exclusion based on sex, but taking into consideration peculiar nature of duties to be performed by electricity workers. It's not violating the Article 15 of Constitution. Kerala State Electricity Board, Trivandrum, Mrs. Sinijia Board. Horizontal vertical reservation. The principle that reserved category candidates get appointed against a non-reserved post will not be counted against a reserved quota. It applies only to vertical reservation, but not on horizontal reservation for women and handicapped person. Public Service Commission Uttaranchal is Mamta Bisti. Life insurance policy for child. When a life insurance policy for a child is based on the stipulation to the effect that it is shall stand cancelled in the case a life assured dies before the deferred date. The action of a corporation is not unfair as regard as a defrated deed under the special circumstances. Life Insurance Corporation of Ranjiv Kaushal. Medical College Reservation. The reservation of medical college is permitted. Ajay Kumar, state of Bihar. Relationship with Article 14 in the sense of the general and abstract principle of equality. Later on, the Article 14 is spelled out certain situations in greater detail in Article 15, and it comes to the succeeding article. But it would be it is noted that it's noted that the Article 15 is limited to citizen, while the Article 14 extends to all person. Secondly, Article 15 Clause 1 and Article 15(2) is both limited to discrimination on the ground of religion, race, sex, place of birth, and any other. Thirdly, the article permit the state to make a special provision for women and children. Fourthly, the articles also permit the state to make special provision for the following: socially, educationally backward citizens, scheduled caste, scheduled tribes. Article 14 prohibits the state for denying any person equality before the law. And Article 15 and 16 protects a citizen against the discrimination. State of Sikhism, the Surendra Prashant Sharma. Reservation and Supreme Court in the state government. SC and ST. Scheduled caste, scheduled tribe. The state government is competent authority to decide the question of reservation of seat against scheduled caste and scheduled tribe in a medical college. Gulstan, Prashant, state of Haryana. Reservation on basis of domicile. The term place of birth occurs in clause 1 of Article 15 but not domicile. If a comparison made between Article 15 and Article 16 too, it would appear that whereas the former refer to place of birth, alone the latter avoids both domicile and residence apart from the place of birth. A distinction, therefore, has been made in the members of Constitution themselves to affect the expression place of birth. It is not synonymous to the expression domicile, and they reflect two different concepts. In a way, true and both expressing appear to be synonymous, but some of the members of the Constitutional Assembly, but the same cannot be the same guiding factor. Reservation on the basis of domicile is not impermissible in the terms of Clause 1 of Article 15 of the Constitution of India. Saurabh Chaudhary, which is Union of India. Rule of reservation non-applicable in medicine. The rule of reservation is not applicable for specialty, super specialty faculty posted in medicine. The Faculty Association of AIMS, Union of India. A scheduled caste acquired scheduled caste status. A person by a region of marriage alone cannot ipso facto become a member of scheduled caste or a scheduled tribe. Meera Kanuvari, which is Shunita. Social promotion. The historical disadvantaged group would be given a special protection so that they can be uplifted from the poverty and low society status. Kailas is the state of Maharashtra. University wise reservation. The university wise preference is valid and it is reasonable. Domicile wise preference is valid and it does not exceed reasonable limit. College wise preference is bad. Mohan Bir Singh Chawla is Punjab Ka University, Chhattisgarh.